And we go back to the big story of the day, really. That's the issue around Jacob Zuma, the former president. Well, his advocate, Dali Mpofu, says Presiding Judge Piet Koen's handling of the matter is, quote-unquote, irregular. This has been part of the bid to remove Prosecutor Billy Downer from the former president's corruption trial. Let's unpack today's proceedings so far with legal expert Mpumelelo Zigalala, who joins me now from Pietermaritzburg. And Mpumelelo, good afternoon. Thank you for your time. Let's start first with the at the beginning, the arguments by Advocate Dali Mpofu and Thabani Masuku in support of them, being granted leave to appeal against the earlier decision against the special plea that had been presented by Mr. Zuma. Just what did you make of the overall arguments that they presented in support of their bid for leave to appeal?
They're basically overemphasizing the results or the implications of such a dismissal in this particular application. And they are saying it's going to be a travesty if we go into the main trial without having traversed this particular issue of assessing whether Advocate Billy Downer actually does have title to prosecute. Linked to that is this. They're then saying the definition of title to prosecute must not be looked at in a narrow sense. Let's look at it in a wider sense of saying, let's take even the conduct of the prosecutor, especially in this one, it's unique circumstances where you have the prosecutor that has deposed into an affidavit made by a third party, basically disclosing information which would have obtained within the course and scope of his employment. Can we take that to be a prosecutor that is titled to prosecute, or should we widen the definition as it is? As we are talking now, the only leading case in this particular matter has only been found in the SCA, or it is only the SCA that has decided the matter. Isn't it prudent for us to say, let's go to the SCA or even the Concourt if we have to, so that this matter is settled for once and for all, and not to wait up until the trial has been done and only then go and take the appeal in a multiple of cases or issues that must be looked at. The interest of the former president, especially under Section 35, they are emphasizing that they are super important. They must be protected. Those rights must be protected. And one of the ways in doing that is to say, go to the SCA, get this matter done and dusted, then come back here and check whether that person has a title to prosecute before we move on to the main trial and bring in the first witness into the witness box.
So if I understand you correctly, then Mpumelelo, the arguments there amount to them saying that the current definition of title to prosecute actually needs to be expanded to go beyond the formalities of, are you someone who's fit and proper in terms of your qualifications, experience, etc., duly authorized by the National Director of Public Prosecutions or one of the directors of public prosecutions in the various provinces, as Billy Downer has been certified at the time by the person who was Director of Public Prosecutions. They want, from what I'm hearing you summing up, they want even the conduct of the prosecutor to form part of the characteristics of what it means to have title to prosecute.
Definitely. Linked to that is, let's look at the definition or what is written under Section 35 of our Constitution, which says that every accused has got a right to a fair trial. A fair trial basically means that even a person who is going to prosecute me must not have any ulterior motives, quote unquote, must only be limited to the work and to the job or which has been appointed to as a prosecutor and nothing else. Someone who has displayed a conduct of even using other means of making sure that I'm prosecuted, can we really say that that person really has title to prosecute me, or that person has got other ulterior motive, or he has gotten so involved in this matter that a new prosecutor in his shoes would be able to do the job adequately?
Mpumelelo, before I run out of time completely, let me ask you then, there are always two sides to these arguments before the courts. The response by the prosecution side, the National Prosecuting Authority's representative, Advocate Breitenbach, I found it quite interesting. Basically, my understanding of it, he's saying that the prospects of success by Mr. Zuma on appeal are, there are no reasonable prospects. And he's basically saying that he would need to convince the SCA that they got it wrong in that other all-important case.
Definitely, that's what he's saying. And he's saying based on what has been presented, let's remember, once the record has been sealed in this particular division, if you go to the SCA, you can't produce any other evidence that is there. Hence the application which was made by the former president of saying, I want to amplify the evidence that I've provided or the submissions that I've made in this honorable court when the SCA is taking this particular decision. However, as we stand now, the law is very clear as to what does a title to prosecute mean. It is very clear as to what principles must be looked at, which is a narrow definition in that sense of saying we only look at the instances of compliance as per the NPA Act and nothing else. If that's the definition that has been taken, that is what we have to go with. In addition to that, they are then saying deal with the appeal in a wholesome approach and don't separate it into piecemeal approach, because once you allow this particular instance to go up to the SCA, who knows what other disagreements may turn out during the trial stage, and are you still going to allow those to go through to the SCA? Why don't you deal with the matter from start to end and only then take it to the SCA when the SCA will have to make a decision on a number of cases or a number of points?
All right, thank you for that, and I appreciate where you leave it off, Mpumelelo, because you really do a great job of summing up, quote unquote, the story so far. Because when we pick up at 2 p.m., that's exactly where we will pick up. That's exactly where Advocate Breitenbach was at the time at which we took the adjournment, the lunchtime adjournment. That's legal expert there, Mpumelelo Zikalala, summing up what we've heard so far in the State versus Zuma matter that is being heard today. It's back again at 2 p.m.